friends, welcome to the 290th edition of Legal Empowerment through Interaction Lecture Series Littles. It's a momentous occasion for us. Over the years, this platform has brought together some of the finest legal minds to discuss issues that matter both in courtrooms and in our everyday lives. Since its inception during the COVID time, Littles has been a platform for meaningful dialogue, bringing together eminent jurists, thought leaders, practitioners, and students to engage on issues that are not only legally significant, but also socially relevant. Not just points of law, but also wider human and social realities behind them. Today is no exception. Our theme for this evening, Global International Citizens and Indian Laws, a Quagmire, addresses an increasingly complex reality. It resonates strongly in an age of unprecedented mobility. The more we cross borders, the more our laws are tested, especially when it comes to family, rights, responsibilities, custody, all those things that span countries. As borders blur and mobility increases, questions of jurisdiction, personal law, and cross border rights and obligations have become both urgent and intricate. Navigating these challenges calls for not just legal expertise, but also sensitivity to human stories at their core. We are privileged today to combine our discussion with the online release of the important new work, Practitioner's Guide to International Family Law, an Indian Perspective, authored by Mr. Anil Malhotra, an integral part of our family, and his son, Mr. Ankit Malhotra. This book is a timely contribution to the profession and a valuable tool and resource for anyone engaged in cross-border family law matters. We are deeply honored to have with us a galaxy of distinguished guests this evening to render the opening remarks and to do the honors of book release. We have as the chief guest Mr. Justice Muhamed Mustaque, Judge of the High Court of Kerala, and an eminent panel led by Honorable Mr. K.S. Garewal, former Judge Punjab and Haryana High Court. Then we have Mrs. Geeta Ramaseshan, Advocate High Court of Madras, and another family member, Mrs. Mrunalini Deshmukh, IAFL Fellow and Advocate High Court of Mumbai, and distinguished dignitaries who will felicitate the authors. The person behind the whole show, in the sense like Littles is today only because of him. I'm sure about that. Honorable Mr. Justice V. Ramkumar sir, Honorable Mr. Justice K. Ramaseshan sir, and representing the publisher, the founder and director of Oakbridge Publishing Private Limited, Mr. Srish Chandra, is with us. We also look forward to hearing from the authors themselves, the closing and the remarks regarding how the journey of this book and the journey in the specialized jurisdiction. And the vote of thanks will be rendered by Mr. Ranjit Malhotra. I welcome you to an engaging evening of perspectives, insights, and experiences, to an enlightening session rather, one that explores the legal labyrinth of global citizenship in the Indian legal context and offers practical insights from those who have navigated it at the highest levels, the whole lot of. Now, without wasting any time, may I request Honorable Mr. Justice Muhammad Mustaque sir to render the opening remarks and do the honors of releasing the online release of the book.
Thank you, dear Shyam. In fact, Roshan Dalvi is also present online, along with the many other dignitaries. I also welcome you. Your thoughts, your inputs are all matters for the discussion. Today, we are all discussing about recently launched book of Mr. Anil Malhotra and his son, Ankit Malhotra, The Practitioner's Guide to International Family Law. In a country where we have around, I think it's nearly 3.5 crores NRIs, non-resident Indians. And Kerala accounts 10% of it, at least, I believe. Chandigarh is, of course, is second or maybe the most the Union Territory, which is having highest NRIs of presence outside India. We face host of issues in relation to the family, custody, property, many other matters. But we don't have any codified private international law. Private international is not an international law. It's, of course, its nomenclature deceptive sometimes. It's an approach of a domestic court of an issue of having a foreign element. As far as in India is concerned, our private international law is catered in few of the enactments like CPC for in aspect of recognizing foreign judgments. Some extent in Succession Act, some extent in Guardian Wards Act. Apart from that, we don't have any very the laws which would otherwise acknowledge the private international's presence in domestics. Now, today we hardly see any difference in public international law and private international law in dealing with individuals. By and large, we see that public international law principles is also adopted in to the private realm and private relationships. This is exactly one we have, the Anil Malhotra was speaking about, one matter where I had to deal with nationality principles and how the country has to protect, as a state has to protect the national, is on citizen in the foreign jurisdictions, which is in fact part of the public international law, but it can also be extended to the domestic level. In the same way, we face a lot of issues, custodies, the disputes in regard to the status, the relationship disputes, the issues of jurisdictions, issues of foreign enforcement of foreign judgments. These are all matters which is an ordinary practitioner cannot comprehend. And as a result, we deny justice to many because of our lack of expertise in this area. This is exactly we need to discuss. By and large, the family lawyers who practice on family courts do not have an expertise on the private law. Keep aside on the part of the public international law. So approach, all the need in such situation is all about is approach to the issues and disputes. In a matter which came before me, which Anil Malhotra was sharing to you, it's a matter regarding the issue came before me. It's on a rejection of some appointment of a guardian before the under national tracks by the district before the district collector came as a writ petition before us, and another habeas was filed before us, and nobody knew what to do in such situations. Anil Malhotra's expertise and his role as amicus curiae became helpful for me to decide that case. Extending the principles of nationality principles is often recognized in the public international law. We were able to resolve that issue. But how often we will be able to use them? That's question. That's something which we need to discuss it. The country where, as I said earlier, 3.5 crores of NRAs, and the state where I think it's nearly 3 or 4 million people working in NRA. They have no, access to the formal system of justice in this country. Obviously, they believe they will not get, their issues cannot be agitated or adjudicated in this country of their origin. Of course, it is possible. So what private international law states about how the issue can be comprehended, accommodated under private international. What are the types of jurisdiction? Yesterday, one of my relatives came here, and in fact, he was lamenting the court in Australia. The courts in Australia have passed certain orders in regard to the property owned by him here in Kerala. It may be like husband might have, it's projected as of course, a matrimonial property, or an asset owned by the couple in the long-standing relationship. But what is the law is all about in regard to immovable property, whether law of situs has to be followed or the law of the domicile of the parties will have to be followed. These all small issues, but would have a larger impact. Unless lawyers are equipped with dealing with such issues, they may not be able to give justice to their parties. They will not be in a position to expose the cause of the client. Similarly, in what grounds the foreign judgments? When you look at the foreign judgments and most of the judgments from 1963 onwards, in recognizing foreign judgments, again there would be a host of issues would arise. Renvoy, double renvoy, all this would arise. So private international is poor in the sense it's scattered in legislation, but still is perverting and some part in some way it affects us. And the court is also not equipped with a deal with such issues. So these are all problems for a day-to-day practitioners. And this book, in fact, will help them. It's will be a practitioner's guide in practical sense, rather than discussing or deliberating on the philosophical aspects on the theoretical aspect of it. There are enough and more theories in international law in regard to jurisdictions. There are enough and different principles evolved in the private international part of it. But the authors have not focused on those aspects, rather than focused on the practical reality faced by the litigant and give a solution for them. This is what has become a practitioner's guide. You may be able to read principles of private international law or public international law from Ian Brownlee or many others authors. You will be contented with the theoretical part of it, jurisprudential part of it, but come to the level of practice, it is not easy. We need to look at the case laws. We need to look at in shaping the cause, the approach. All that has been considered in this book in different level, in regard to custody, in regard to jurisdiction, in regard to the recognition of foreign judgments. All this will become so handy for the practitioners, and they need only to refer this book for the purpose of their day-to-day cases. I think everybody should own this book to understand, at least, even if they are not regularly practicing on this family law. But this is something you require to know. Especially, and I would recommend those who are practicing family court, this must be there as a part of their library. When I was dealing with the roster of the family court jurisdiction, I found so many cases are coming up, and parties are not in a position to appear before this court. In some of the cases, it's obvious. The one party may get a judgment in foreign court, an ex-party, and it will be used as a shield, or sometimes it is used as a weapon. Sometimes it's a regular feature that child is removed out of the jurisdictions. Now, I would appeal again in this background. It is also we need to develop some institutional mechanism for the mediation. This is one of the big challenge for all of us, because the route now all of them choose is through the formal education through the courts. The mediation is a very problematic and international scenario, because there are issues of culture, issues of language. All this will become a barrier. But today we can have a kind of cooperation among different institutions across the globe, which provide kind of assistance. So one party may be German, other part may be Indian. So it can be two mediators, one from India and another can from German. Of course, as far as the mediation is concerned, all of you know, it's a non-partisan. They are neutral. they can also bring some sort of solution to the disputes instead of the battle through the litigation, different level up to the Supreme Court. I think we also need to bring along with this the discussions. At least give a foundational thoughts to have a lay down norms and code of conduct for international mediation. So we can lay down some foundation, the ethics to be followed, the procedure to be followed. So meeting of mind of different from the people from different jurisdiction would help the parties to solve the issues amicably rather than the fight through the corridor of the court, most often using ingenious methods or dubious methods. It is fashioned by the lawyers often. So I'm sure next attempt of Anil Malhotra and his team to focus on some sort of developing the institutional mechanism for international mediation. That was possible, especially when our country is taking initiative for mediator settlement, having the same cause of the decree. So it's all about developing institutions through the norms and values to be followed, which could have some sort of accreditation. And I think that should also be a focus. We also need to discuss about developing international mediation. At the same level, we have developed the private international law. So with these words, I conclude. I open the discussion for on the subject on this book. We expect this eminent personality who deliberate and gave their thoughts on the various topics touched in this book. Thank you. Thank you, Hon'ble.
Sir, you can also declare that the book is released so that we'll deem
And
it
I
as
also formally declare that book is released. I have a book here with me.
Yeah, me too.
Very colorful book. The print and the front cover all is appealing, and it's quite enjoyable to read also.
So I don't know what Shyam exactly means by me too.
I have the book with me, and that's what I said. I didn't want to show it in the audience because it has to be by you and the chief guest. That's it.
Sir,
Thank you very much.
Justice Mustaque, I want you to briefly tell us about the initiative of the Kerala High Court on the Child Legal Assistance Program and the Child Independent Support Lawyer, because that is the most unique thing which has happened in the country.
CLAP is something which I suggested, Child Legal Assistance Program. In fact, it came through a judicial order from me, and I don't remember who was my. I think maybe so. Justice Dias, or I don't think Justice Dias. By the time I think it's Sister Sophie, I believe,
So,
or Shobha. I don't remember exactly. Then, of course, then I became the chairman of Legal Service Authority. We drafted a scheme. We have lawyers who are assisting us in KELSA's activities, Advocate Parvati Menon and many. So their thought process went in, and we formulated a scheme. Based on the scheme, because you know that the National Legal Service Authority can have a panel of lawyers in different level. So we made a panel of lawyers. After the interview and selected each district, we have a panel of lawyers and we gave them a training. And they are not like a normal lawyers. They are not permitted to argue the cases before the court. Because my own experience, I realized in often court, when the matter of child custody, the father and mother, they project their positions rather than, of course, in relation to the child, but it is more of projecting they are the one best to protect the best interest of the child. In that process, the court ignored what is the best interest of the child. And the child, of course, one or two occasions, the judge may get an opportunity to interact. But beyond that, absolutely no interaction. There is no background checking of the child. There is no interaction with the school, the teachers. There is no interaction with the neighbors and others. absolutely no other information is collected. In court process, court then ultimately adjudicate custody is given to father or mother and weekend custody to someone. So court is rather court is rather trying to balance something.
You are not audible.
Sir, somehow it has been muted. Please unmute, sir.
Court often, like as you all know, this the family judges are the human. They go by social values or moral values of their own ethos. So they maybe believe that the women is of a loose moral, therefore child should be given to father, or they may say that father is not in a is working, he may not be in a position to take care of the child. These are the perspective of a judge, looking at either father or mother, rather than looking at the child. Child, sometimes it may not require either father or mother to take care. If somebody else may be the best to protect their interest. But who knows this? Neither, it is not necessary we should appoint mother or father as a guardian. We are only need to look at the best of the child. So project started in such way, we train the lawyers in the CLAP project. They will be interacting with the child. They will ascertain their wishes. They will, we have given their the guidelines to them, how to get all the information. They will gather. They can also activate other machineries under like the Joint and Justice Act, the Child Protection Officer or District Protection Officer. They use all this mechanism and will gather all the information and will be placed before the court. So that information will be decisive for the court to decide how to protect the interest of the child. So focus of the inquiry in that process is on the well-being of the child rather than the positions of asserted by the parties before the court. So now we have a system in this place throughout the state, the CLAP lawyers, and we have a steering committee headed by Justice Dias. He is a project coordinator, and there is a practicing lawyer, I believe, Advocate Sandhya from Trivandrum. She is the state coordinator. So they coordinated the activities. So CLAP lawyers are panel lawyers under the KELSA scheme, and they are paid out of house schemes. They will only report to the court. They will not take sides. They will not permit it to argue. Of course, any further information is required from for the court. Court can direct them to place those information. So the child is under the care of the CLAP lawyer, and court will not merely go by the version of mother or father in deciding child custody matters. So this has become a successful project in Kerala. Of course, a long way to go. Even the judges also need to be very sensitive, because judges also need to steer and streamline the conduct of the inquiry to be done, because it's all in a case-to-case basis. So judges also need to be sensitive in such matters, dealing with the CLAP lawyers.
Kerala, sir, is the only state in the country which has pioneered this and is going on. Everybody else is yet.
I think Bombay is attempting it. I think I saw some judicial order from
It is only on paper, sir, for the time being. Anyway, sir, as you have set an example, the road is open now.
Oh, that's because of me. I became the chairman of the legal service so that I could implement it.
And I got to know of it because you asked me to address on it. So
you addressed it. That training program, you addressed it. One of the session you addressed it. There was a training program in High Court. All the lawyers from different parts of the state came. And it is being monitored also by the project coordinator as well as steering committee. Because that is also necessary. And while selecting club lawyers, we also to be a bit sensitive. I mean, they should not convert it as another litigation for them. The integrity of the lawyers is sometimes is very tricky, and they will also give advice, and that we don't want to. I mean, we don't want to give sort of any advice like some of the mediators tend to do such things in mediation. They become so subjective and express their opinion. So we also ensure that they do not cross their limit.
So, Sir Shyam is always available to you as intelligence officer to monitor.
Police officer. So thank you very much. And now that the formal function of book release is over, we'll just move on to the panel discussion. And to lead the discussion, may I request Honorable Mr. Justice K.S. Garewal, sir. So over to you.
Thank you very much, everyone, and to all. I'm sitting in a village in Punjab. It has been pouring cats and dogs, and it's all flooded outside. But still, it's nice to be on this panel. It's very interesting for me because I'm not a lawyer. I'm not a practicing lawyer. I left the bar 40 years ago. So I'm on the other side of the fence. And I have seen families break up, families fight. I've seen couples fight in court. When I was a trial judge, that was also about 25 years ago. I've had all kinds of cases. And once we had a case, the husband was sued for divorce and the wife appeared respondent. And so all I asked the wife was, who is this standing next to your husband? She says, he's a baboon. So, hey, baboon's brother, they're both baboons. So the fight started. What to do? Then ultimately, they made a complaint against me that he is provoking us and all that. So the case was taken away from me. So all kinds of things I've seen, I've watched. I've watched that old time when you were under the watchful eye of the High Court. And in fact, Mr. Malhotra, you'll be interested to know, 1987 Punjab, I'll tell you the page later, AIR 1987 Punjab. There is a one sentence of the High Court which set aside my order, saying that this order of the additional district judge is ultra vires the constitution, and without giving any facts, nothing, and got it published. It was all done to malign me. But what do? You just have to keep quiet. You can't do anything much. However, I must congratulate you for your book. This is your 10th book, huh? So,
Some problem with
be a
your
full team.
connectivity.
So your voice is breaking.
Can you hear me now?
Now it's okay.
No. Okay. Sorry. No, I'll be careful speaking. So for a practicing lawyer, now all of you are lawyers, and of course Justice Mustaque has been a lawyer and now a judge. So it is your duty to keep writing books. You must write. You must put down your experience to share with everyone. It is not that something you keep like old-time Brahmins, who kept all the knowledge to themselves, would not share it. And the result was we were a weak country because the Brahmin said, fight, you fight. The Brahmin said, don't fight, you just sit quietly, and the invaders would come. So my point is that lawyers are duty-bound to write. It's very easy to write, actually. You arrange the headlines vertically. You have a digest. You arrange the headlines horizontally. It becomes a textbook. Textbooks arranged alphabetically make an encyclopedia. And every few years, some lawyer breaks up all these books, puts them all together again, adds a few latest judgments, and stirs well, and you have a new edition. So writing. I'm sorry, Anil, for I don't want to. I just want to add 2 points, just 2 points, which you haven't touched. One is a point Justice Mustaque touched a little bit about counseling and how mediation should work. But you see, mediation is when there is a dispute, but there is counseling when couples are having trouble. There should be some system where they can go, some organization, some social work, some people of the community who can help them to overcome their little ups and downs of married life. And they're not few. We've all seen within our families, within extended family, within friends, that people are having trouble. And that we should have a mechanism for counseling before mediation, and then mediation, of course, because all matrimonial cases end up. I mean, it's just takes so much time and so much money of the parties, so many problems faced by them, lawyers coming up with all kinds of pleas just to prolong it and to harass the other party. So they finally do end up in Davos, and custody matters are then issue. And the other very important point I want to introduce is that at least in North India, we have a lot of disputes within families over property. And sometimes a family member is abroad, if he's sitting in England or in America, and the property is situated in Punjab, and it is disposed of by the will of the head of the family. He writes a will. Then after he dies, the disputes start. The agricultural land, they go to the revenue department and the will is accepted and the mutation is done. But the person sitting in England probably doesn't know all this is happening behind his back. So he comes to India and then he says this will is a forgery. So that becomes a criminal case. So you go to the criminal court, again, litigation. And finally, you file a suit to uphold the validity of the will or to say it is declared to be invalid. What I want to suggest is compulsory probate of all wills. Once a probate has been done, 2 witnesses have been examined, and party can hold the probate and then go wherever to recover the property. You see, we don't have the practice of probate. We are still living, I'm sorry to say, we are still living in the colonial era, when they wanted parties to remain unsettled and no dispute resolution, always fighting in courts, always going, and even your 3 new criminal laws are not new criminal laws. They are the old laws just renumbered and a few amendments introduced. And they say they've got rid of the colonial era. They have not. In fact, Macaulay is laughing at the mess we have made of the criminal system. Nothing happens in this country, nothing happens quickly. So you introduce an element of private dispute, and voila, you have it goes on and on and on. And all kinds of petitions are filed in 482 SLPs, but no end. So these are my 2 suggestions. And thank you very much for asking me over. And well, I enjoyed this. I'm sorry the connectivity here has not been very good in the rural countryside. So I'll close now and leave it to the other members to express their views. Thank you very much.
Thank you. Thank you very much, sir. I'm sure that the water level is not rising there. I mean, still holding good. because of the raining.
No, we made
Rains,
arrangements.
now may I request Advocate Geeta Ramaseshan, ma'am, please. You'll have to unmute. You'll have to unmute, ma'am.
Good
Thank
evening,
you.
and thank you very much for inviting me to be part of this participation today. Actually, I came across this book about 2 weeks ago when the booksellers, in the High Court campus, the booksellers keep selling the books, right? So they brought this book to me and said, "Is this a book you would like to buy?" And the moment I saw Mr. Malhotra's name, I decided that this is something that I have to have, because I have his earlier one, that is the removed child and the law in India. And I really liked the way in which this was written. And I found that being a practicing lawyer, I found something very interesting as far as this book is concerned. Even though he talks about it as a practitioner's guide to international family law, I find that the many judgments that he has actually referred in a very nice, actually both the authors have referred in a very nice chronological way, can apply to cases even those evolving in rural areas. And that, I think, Mr. Malhotra, is a great credit that I can give to you and to Mr. Anil. Having said that, I just want to share a few of my thoughts in this regard. And I just want to share the difficulties that lawyers face in a very different way, because a large part of the discussion has been on sharing of our experiences. That family law, the Indian family law has become truly international in many ways, in the way in which there are cross currents of cases being filed across different parts of the country, where there is also in many ways a forum shopping that happens, which we all know about. Now, the law to my mind, has also become very judge-made, because the judgments give a lot of guidelines, give a lot of information, the information of which is sometimes used as a strategy in trial courts. And the plethora of judgments, I would say, try to bring about or ease some of the difficulties that statutory law actually causes. I mean, most of our statutory laws are now more than 70 years old. And definitely we need to have a rethinking in that area, which judgments, of course, have eased it, not just in the area of looking at marriage, but also in the area of developing the notion from parental rights to the child to the welfare theory of the child, which based on the tender age theory, to now looking at the best interests. Now, what exactly is best interest today depends upon how the courts look at. And as His Lordship Justice Mustaque pointed out, a lot of one's own social norms and the way one thinks of it comes in an approach to dealing with the issue of best interests. Now, in the context of our own laws, when we are looking at dissolution of marriage, every part of it is actually based on the fault finding notion, where despite the Family Courts Act stating that Evidence Act does not apply, hardcore evidence is always necessarily brought into the dispute and the litigation, otherwise which the case is not taken, the case does not stand scrutiny in the trial. So such being the case, when substantial law requires proof and substantial law addresses allegations, primarily cruelty, adultery, desertion, etc., evidence is all the time required, despite the Family Courts Act, which say that is not so. And that, I think, to me, is a problem in the way that comes to in the litigation, because all of us know lawyers definitely will create some kind of an evidence. Even the best of lawyers. And for example, I can just share with you this. For example, you talk to a couple and, you ask them what are the good moments, or you ask them to write and tell you what they are. And when they write and tell you what they are, they would be sharing some good moments in their life. But you do not, as lawyers, apply or put the good moments in the pleading, because sometimes or most times the courts look at that as condonation and say the acts have been condoned. So condonation again is a very problematic provision in our laws, and there are many judgments that address this condonation, at least in the trial courts, which despite a domestic violence act looking at abuse, despite lawyers saying that a person leaves a marriage only after they move away, is not accepted. So in that sense, there is also a lot of age discrimination or ageism, where the presumption in our courts always is that, if a more senior person above 50 come to court, the presumptions are always, if you have lived for so long, why not continue to do so? I mean, this has been my experience, and that is one which I thought I would share with you, the way in which court looks through. But having said that, the concept of irretrievable breakdown also will have problems in the Indian context, because if that is introduced as a law, how will it pan itself out in smaller towns, in rural areas, where a man can just say, my marriage has broken down irretrievably, and therefore, say that I do not want my wife. What could be the balance between these two arenas, to me, seems a great challenge, the way in which we can actually address family law. In the concept of invoking different forums, and your book mentions a lot of that, and all of us in our experiences know couples living abroad find that if they want to drag their spouse in India and make it more problematic, they would come and choose the Indian system, because jurisdiction in India would arise if the marriage was performed in India, even if they are not citizens of India. And so concepts like restitution of conjugal rights, which does not exist in many of the countries across the world, is often used as a tool to force a situation. I've had the experience of a couple who had lived in USA for 25 years, having been citizens. And when the wife initiated proceedings for divorce in the USA and asked for sharing of the property, the husband came immediately to India and filed a restitution of conjugal rights, obtained an ex parte order giving her old Madras address, and after obtaining an ex parte order, filed obtained an anti-suit injunction, and when the court proceeded ahead with it, also filed a contempt. And this, of course, in the High Court, we were fortunate enough to quash everything. But despite the fact that this was an instance of how proceedings and different, can be misused in more ways than one. This also happens in the area of child custody. Spouses want a fast divorce in America, but come away immediately to India, because the law with reference to child custody, by and large, is more favorable to the mother. And so there are cases where the mother has come away. The one pertaining to Dorothy Thomas in Chennai, where the judgment was delivered by Justice V. Ramasubramaniam when he was here, where in a very detailed judgment he had elaborated on the way in which forum shopping takes place in matrimonial matters, and held that US courts alone had the jurisdiction to do so. I found in the book the way in which the table has been done with reference to child custody matters very interesting, and gave me an idea of an absolute ready reckoner to look at judgments. I also was very, I found it also very fascinating and interesting the way, Mr. Malhotra, you have brought in the Hague Convention, because the Hague Convention, again, people have two minds about it. at one level, when I look at cases and I look at the way people have misused the law and come away to India, I feel at that point that we should sign the Hague Convention. But at another level, I'm also able to see the protests of the women's movement and their opposition to the Hague Convention, because they feel that the Hague Convention would be for a man to obtain an ex parte order abroad and then come to India, or if the wife has come away, especially when it comes to custody, and then kind of set the law in motion here and harass the wife. And especially where in the West the concept of joint custody exists, whereas in India a mother has a preference for the custody, especially when the child is very small. So I think these are the nuances you have also touched upon in the book, which I found very fascinating, and I found that this has been very, very interesting. I just want to one problem the negative side of our child custody litigation is, at least in my experience in Chennai, is the long time that it takes to get even an interim order on visitation for the parent who does not have the child. And during this time, the child, of course, is tutored is a Evidence Act word, but I'm using that, is completely tutored by the other parent or controlled by the dominant parent, resulting in visitations often becoming a mockery. And this problem of time, where is an issue that always needs to be sorted out. But the notion of joint custody, which does not exist in the Indian context, except when parents themselves are willing to bring about or formulate a rule to that in their area, is something that we actually need to address more and more. Unless we feel that one parent is abusive or alcoholic or in a way unfit to have a joint custody process, but even such a parent would be entitled to visit the child and have the company of the child. That is the general principle. But this is something that we need to look into and consider. Sir, I just wanted to share with you, your lordship, about mediation, because I'm a senior mediator in Chennai. And of course, we have not had international mediation where one party is not of an Indian origin, but a foreigner. Because now we can do the mediation in all our courts online, we have started doing that online, where even if the person is of Indian origin and is living abroad and is a foreign citizen, appears. This is because we felt that criminal cases are filed against the husband's family in India, so therefore he is petrified of coming here. And we found that through mediation online, it's a much easier way to actually resolve the dispute, if it can be resolved, because he would not want to come. And so with online mediation, this of course, in these cases, they have a lawyer in India because they are of Indian origin. Sometimes they may have families in India. And I think, sir, your suggestion that mediation has to be put forth and pushed forth in a big way with good mediators, of course, in an appropriate dispute resolution, as Mr. Sriram Panchu would call ADR, is something that we really need to consider. I just want to conclude by saying that two things. Once again, compliment the authors for this very wonderful book, and I wish them a great success. I also want to add one aspect that the book has two chapters, I think, on family arrangements and Succession Act. I really wish and hope that your next work will take a complete look and you will have a detailed book on inheritance, and taking the kind of examples that he gave earlier from Punjab. Because, of course, being a presidency town, in Chennai, probate is a must, but it is not a must in the rest of the state. So these, I think, are other areas which I would look forward to getting to hearing from you. I thank you very much once again for having invited me to share a few of my thoughts with reference to matters pertaining to family law. Thank you.
Thank you. Thank you very much. Can I have Mrunalini Deshmukh, ma'am, please? You'll have to unmute.
Good evening, Justice Mustaque. Good evening, ma'am Dalvi. It's such a pleasure to see you once again. And Justice Ramkumar and all the other dignitaries here. Shyam, thank you for inviting me and making me a part of this panel discussion.
Pleasure.
And a little bit of experience in this is what I would like to share on this occasion. The book absolutely, as I said, is a treatise, and it contains all the aspects we as a practitioner would require to refer to when I am appearing in cases, whether it's at the trial court or whether it is in the higher courts. The points that that Mr. Anil Malhotra has covered and which are the new aspects to it are the laws of surrogacy, because we also do get a lot of queries about what are the laws of surrogacy, what is altruistic surrogacy, what is the 2021 enactment, why there is no commercial surrogacy, what are people supposed to do, and what really falls out is they go to foreign countries and get it done. So whether there is a need to revamp the laws of surrogacy also, because everybody wants to have a child of his own, and he or she, if they're unable to do so, if there is a procedure available, whether that could be adopted within the Indian framework with 100% surety and care that there's no exploitation of the commercial surrogate. The second point that he has very, very which I have learned a lot about it, are the concepts of domicile, concepts of citizenship, the OCI, that is the Overseas Citizens of India. Because today, as Justice Mustaque said, that there are so many NRIs, there are so many foreign nationals, some people of Indian origin who have taken up citizenship otherwise. And these are the kinds of things that creates a lot of issues. And there is a lot of clarity that is required. For me, I have quite a few clients. These are lady clients who are foreign nationals who got married to Indians, and they are here on the visa, or that is what on the OCI card, and the moment the divorce happens, they have no standing and they have no visa to be here. What happens to such kind of women who have children here? What happens to some kind of, and I have a couple of cases that I'm doing where there's a marriage of 25, 30 years. There are assets here, there are children here, and her whole life has been in India. And it's just that she was born in a foreign land. So these are the kind of issues that we deal, and I have gone through the book, and just Mr. Malhotra's book has given a lot of perspective to how that can be done. But I feel as a lawyer, and since there are so many judges here, that we need to have some kind of a judicial activism or judicial pronouncements and interpretations when we talk about such situations. There may be a few, there may be a minority, but ultimately the law needs to be settled on that. Justice Mustaque, you're very, very rightly, and even Geeta for that matter, talked about mediation and talked about sir, I can relate to you that in the Delhi High Court, they have a pre-litigation mediation center. It's an extremely robust litigation center, and I have personally participated along with my clients to get it done. And their success rate is very high. Why can we not have a legislation where a pre-litigation mediation becomes a must, a mandatory thing, rather than getting to the courts and making allegations, wild accusations against each other? We will be able to bring about some sanity in courts, and I'm sure all the judges here, including Justice Roshan Dalvi, who has been handling a lot of matrimonial matters when she was, of course, the principal judge of the Bombay Family Court and later the High Court. It creates a lot of bitterness. So whether that can be avoided. Now, if you see in Dubai, and there are a lot of these expats like Indians who want to file in Dubai, the first thing that they go to the court of first instance is when they file a petition, it is only goes for the mediation. So there is a call which is made by the mediator who is appointed by the court to the other party, that party A wants to go for divorce or certain relief, kindly come and see us. So unless there is a failure report, what's what the word we use, or unless there is a negative report that either the person refused to appear for mediation, or the mediation was not successful, or they were able to mediate, then they take a divorce by on the terms and condition. The matter does not go to the proper court for hearing. I understand in our courts we have certain urgent matters. A wife is likely to be thrown out of the house. A child is likely to be removed outside the jurisdiction of the court to cause frustration to the other person, or such similar things which are happening. Those could be carved as exceptions, and there could be a sort of kind of a situation where we could deal with them. But standard matters which deal with divorce, which deal with custody, which deal with even marital assets or alimony, could be, if possible, given a chance. Of course, the family courts in Mumbai have a process where it's a mandatory counseling that the parties have to undergo. But the difference is, by this time, the litigation is on, the allegations are on, and the party who has received the petition is absolutely hurt or is sort of scarred by the kind of allegations, etc., are made. Whether that gives that person an open mind to work around the mediation and try and see if one can avoid litigation. So that is one aspect that I want to bring about here. I think Geeta also brought about a very important concept of irretrievable breakdown of marriage. Now, that is one, of course, this is by the legislation. It's not that the lawmakers have to do it, and it's not the judges or the courts that will have to take care. Though there have been several Supreme Court judgments where they have indicated or they have requested the Union of India to consider this as a valid ground in the present circumstances of the case. Of course, there will be checks and balances. Of course, that will have to be used, that it cannot be used arbitrarily without anything. But not giving a person a chance to make irretrievable breakdown of marriage a ground. We are opening the floodgates for making allegations, counter allegations, some situations which have occurred, some from the figment of imagination of the client, and others also fueled by the lawyer to make an equitable case on the grounds of cruelty. So all this kind of unpleasantness could be considered and could be avoided and could be done into it, and accepting it. I'm not saying that you grant divorce easily, but we can look at it by making it less aggressive, less sort of vicious, and a little more, if I may use that word, graceful, if people need to part. That could be one of the points that I would like to use this forum to put across. And lastly, and more importantly, Justice Mustaque talked about CLAP and the wonderful work that is being done. Sir, in Bombay family courts also, we are making applications to the courts asking for an independent child lawyer. So the child independent lawyer is appointed by the court. The cost or the professional charges are shared if both the parties are willing, and he or she who is the lawyer reports to the judge concerned, or if there's a counselor attached to that particular matter, about what the developments or what the things are. The idea behind this is, as you rightly said, sir, is to ensure that the child has a voice. Because in all these custody battles, the child is voiceless unless he's of an intelligible age of 14, 15, where his opinion is sought in some cases. But in cases where the child is voiceless, the role of an independent child independent lawyer becomes a little assistance to get to the court to decide, rather than deciding the rights of the father and the mother. The courts in all their judgments are saying that we are here to deal with what are the rights of the child and not the rights of the parents. But somewhere in these arguments, as sir, you rightly pointed out, it does come across the husband's lawyer talking about how he or he is the best parent, the mother saying how she is the best parent, and to show that the other person is not a good parent, allegations are made. And this is something which are happening. As you rightly said, that there was a PIL that was filed in the Bombay High Court with regards to the child independent lawyer, and to make it mandatory. But the court said that it does exist within with the existing system. So I do not think that the PIL saw much of a sort of a future to what their contentions were. But coming back to those are different things. I think coming back to it, that is also one of the things which we in our small way in the Bombay Family Court, I can say for that, I'm not aware of the other, are trying to introduce. I would be honest to say it's not becoming very popular. It's not becoming. Both the parties are not willing to accept most of the cases. It's taking a lot of time. But I would say there is an effort being made by the courts only because they feel that it will assist the courts to find out what is in the best interest of the child or the children concerned in this case. And lastly, and more importantly, sir, as Geeta was saying, and because Geeta and me practice the same kind of law, what happens if a wife gets a judgment from a Singapore court saying that such and such is the alimony has to be done? The parties are married under the Hindu law, and we file a petition here. So these cross-border issues, there is absolutely no clarity, at least I may say so, as far as what is applicable, what are the foreign judgments that can be executed. I know there are judgments right from 1975, Teja versus, and we had Narasimha Rao, then we had the Sondur Gopal, and all these chain of case laws that the Supreme Court has interpreted for us like practitioners and for the litigants to understand what is the position in law as far as the child is concerned, or the marriage is concerned, or the execution is there. But still, sir, on a practical note, and Mr. Malhotra, you will also have to sort of deal with this in a better, and in a manner that could be considered. Though we go by the judgments, there is no clarity. And the difficulties in execution really takes a lot of time. So these are the things that we sort of face as practicing lawyers. And I think, sir, these are the issues that if at some point of time can be addressed even by the courts with the legislation, or even by the legal thinkers that we have on this panel, that will help a lot of us as practitioners and also the courts in getting some kind of situation. There are so many people who are here and I'm waiting to hear from them. But thank you so much for such an erudite presentation of the laws, more particularly cross-border issues. That is a new phenomenon. Obviously, it did not exist when the laws were enacted in 1955. So there is no provision in the existing statutes, whether the Hindu Marriage Act or Special Marriage Act, etc. So this has evolved over a period of time by way of judicial interpretations and also by way of judicial interventions in interpreting what the whole situation is. So there is no law in place. It is just by judicial intervention. Also, one last thing, I won't take much of your time. The Guardians and Wards Act also needs to be relooked into in the present context of the cases. What is the usual domicile of the child? What is a parental abduction? What are parental alienation? So all these concepts are more which are not in the statute, but which we sort of experience in the course of our arguments, in the course of our cases. So these are some of the points that I thought I would just mention. And thank you so much for giving me an opportunity of expressing myself and also to listening to all the stalwarts, the legal stalwarts, the legal thinkers here, which will help me to enrich myself. Thank you very much.
Thank you very much, ma'am. And for the completion of the panel discussion, may I take the liberty of inviting Justice Roshan Dalvi to just offer your comments on what has been discussed till now.
Thank you. Good evening.
Good evening,
I
ma'am.
don't think I have much to add, but I may tell you that throughout the world, people are feeling that there is a lot more that family courts can do but is not doing only because of the numbers. In our country also, we are always bogged down by numbers. As Ms. Deshmukh said, that there are just too many and we don't get the orders quickly. Like Geeta also said, we don't get orders for child matters also quickly. There is an international body, a small person of judges from various countries, including, say, Belgium, Japan, America, Scotland, India, I'm there, and some other countries, South America, for example, where we have the same issues and we are discussing how to solve. What we say is pre-litigation mediation is what is gaining ground. So that most of these matters, whether they are domestic or they are international, quite often they are international, could be resolved before going to court, so that we don't burden the already burdened courts. The second thing is, and I may tell you that only in this month, July or August, there was an international conference in Cambridge where various lawyers and judges from various countries discussed these issues and how to solve them with a paradigm shift. So we don't have only matters of divorce and property and custody of children and put them all together. There are various aspects to it. There is a report which has come out of this organization, which was discussed in the Cambridge seminar. I hope it goes far ahead, because lawyers, mediators, child lawyers, child mediators also. We can be a child mediator, call the child and hear the voice in a mediation, which I've done in some cases. This goes a long way in bringing about an overall settlement. That also is an important thing to consider. Just as we have the CIL, the child independent lawyer, we can have the CIM, the child independent mediator. And we find, I find in some of my consultations that, especially in matters where parties have lived abroad, they may be Indians first, they may have a visa, or they may have a green card, or they may be American citizens or citizens of any other country. Generally, we know about American citizens. One party comes to India, files an application. The other party knows nothing about it, and then everything begins. These are also for matters of children. False or truthful allegations are made. They have to be seen as a whole, but that doesn't happen in these kind of matters. So the judgments that we've referred to and all are of certain importance only and not overall importance. What we need today is the procedure of coming together, discussing and negotiating like a businessman. That would be a paradigm shift. Thank you.
Shyam,
Thank you. Thank you. Yeah, please, sir.
with your permission, I just want to substantiate, add to what Justice Roshan Dalvi said, to what Justice Mustaque said, and what Nalini ma'am and Geeta ma'am said. We need a paradigm shift. We need a revolution. Now, what has happened is that we have not caught up with our colonial laws. So what is happening? Supreme Court is using its ultimate weapon under 142 to sort out matrimonial matters, adoption matters, matters relating to surrogacy, and so on and so forth, because there is no answer in statutory laws. But is our Supreme Court, which ought to be a constitutional court, be doing this? The answer is no. Where is our family law infrastructure? I am a fellow of the IAFL. Justice Mrunalini ma'am has just become a fellow of the IAFL. This is a platform of 700 lawyers worldwide where we discuss these issues. I was recently invited to the US to take part in an international child relocation program where we had 100 closed-door judges and thought seekers on proposing. There is a Hague network of judges. There is the group run by the Cambridge on this issue. Marilyn Freeman runs a wonderful group. So these are platforms where we ought to participate. But I wish to float the Australian model of compulsory mediation and settlement. And next, what I wish to propose is, why can't we have mandatory family law arbitration? In England, whenever there is a problem, There is a family law arbitration. You want to settle everything, go to arbitration. Why can't we have an option to go into arbitration? Before we make it ugly, before we make it messy, and before we multiply it into 10 litigations and keep parties in different jurisdictions, have arbitration. Why don't we amend the Arbitration Act? We do it in commercial disputes. Why can't we do it in family law matters? Why cannot we have a compulsory process? You have to go to court to get a mediator appointed. And until you reach the Supreme Court, you are not interested. The Supreme Court Mediation Center is awesome. It has only senior lawyers and matters get settled. But why can't we introduce something at the grassroots level for settlement even before you go to court? There should be a voluntary clause if you want to go to arbitration. We can't have an arbitration clause in marriage, of course, but at the same time, we have a concept of saving the marriage. We have a sacramental marriage. In the West, all over the world, marriage is a contract. It's all for the asking. Nobody understands it. Wherever we go, domicile is still Indian. So we need a thought process. We need to take away 142's powers and we need to create a mechanism in the family courts. As Justice Dalvi puts it, I am always impressed by the words which he used in one of the judgments, interpreting the word family as father and mother, I love you. How many people think that way? You don't have to file a petition and then multiply the petition by repeating its contents into a guardianship petition, into a domestic violence petition, into a 125 CRP and anti-injunction suit. You need to first sit down and take stock. Put party. I think mediation and having retired judges like Justice Dalvi as mediators could do a great deal, especially when there is a big family. In our book, we have dealt with the concept of family arrangement and settlements in India. We need to develop something like that and have Mrunalini ma'am and Geeta ma'am and other leading experts advocating this phenomenon, going to Dubai, going to Australia, saying we have an arbitration. I often get contacted by English lawyers and saying, do you have an arbitration? We can sit down and sort it out. No. So one end is 142, one end are our antique 1980, 1819 laws, the 55 laws, and the other end is a compulsory mediation process, not a mediation process, step into arbitration. So this is some food for thought, which wisdom perhaps will be better interpreted by Justice Ramkumar and Justice Ramakrishnan sir. So I hand the floor back to Shyam, and I'm sorry for the intrusion, but I thought some whipping up is necessary.
Thank you, sir. Ramkumar sir, over to you.
There is little which a confirmed criminal like me can say about this marvelous book and the subject also. As some of you suggested, is not the Evidence Act and the procedure codes slowing down, slackening the process of trial? Why not we scrap at least the bulk of the Evidence Act and the procedure codes? I don't say the entirety of the statutes. The bulk of the procedure, the Evidence Act and the procedure codes in such litigations. Why not give the power of doing complete justice give to the Supreme Court alone? Why under Article 142 Supreme Court alone should give complete justice to the party? Why not confer such a power to the trial courts?
Absolutely.
The high time that we see the bulk of these statutes. It is high time we devised a system to quicken the pace of litigation, civil and criminal. I'm saying, how many years, how many decades a criminal case is taking? Ultimately, when a final judgment is pronounced by the Supreme Court, and can we say that is the correct judgment? As Justice Krishna once opined, the judgment of the Supreme Court is final because there is no further appeal from therefrom. If there were a further appeal, it would have been different story. So I think the procedural laws should be liberalized, and to tailor-made to suit our present requirements. How many years our civil and criminal litigation take for reaching finality? Now coming to this book, the marvelous book co-authored by father and son, the great Malhotras. In the pantheon of living legends in law, Anil and Ankit Malhotras occupy a very prominent position. Mr. Anil Malhotra, who has already been enlightening us in this platform through his webinars, richly deserves to be a fellow of the International Academy of Family Lawyers, IAFL, comprising of 79 countries. That itself indicates his deep knowledge and expertise in the field of family law. Although he is a family law practitioner based in Chandigarh, he is a globally sought after authority on Indian family law, particularly the cases involving non-resident Indians and international family disputes. The enviable profile of a double LLM, one from the University of Chandigarh and the other from the University of London, speaks volumes about the acumen and resourcefulness of this great forensic specialist who is adept in harnessing the statute law as well as case law to his advantage. Equally brilliant is his son Ankit Malhotra, the co-author of the book. He too has many feathers on his cap.
And sir, 1992 LLM from SOAS. He was also
Great. Yeah, let me frankly confess that except browsing through a few pages, I have not conscientiously read the book, a copy of which was munificently forwarded to me by Mr. Anil Malhotra a few days back. I was actually engrossed in preparing a legal opinion in an important case, a great important case, of course, a criminal case. The book, now under online release, appears to be an encyclopedia on the nuances of family law, which at the national borders have been euphemistically described as under a quagmire. You are absolutely true. In fact, the lawmakers are so slow that it will take years and if not decades to catch up with the law and the practice abroad. But I can really say that this book is not merely a practitioner's guide, but an authoritative treatise on the subject, the benefit of which will surely be reaped by both the bench and the bar. What an introduction by former Supreme Court Judge Justice A.K. Sikri. I am a great fan of Justice Sikri. See the dual route in the process of tendering pardon to an accomplice in a criminal case. He has beautifully written that judgment in CBI Chennai versus V. Arun Kumar, 2016 Supreme Court judgment. I don't remember the page number. Beautiful judgment. In fact, it affirms the view of Justice Hidayatullah way back in 1968 that Commander Pascal Fernandez's case. In fact, there are two other judgments which are absolutely, I would say, ridiculous. Supreme Court only. But I am a great fan of Justice Sikri. He has written a great introduction in your book. Then the meaningful forwards by Justice Mustaque and Professor Werner Minsky, and the note of appreciation by Senior Advocate Mr. K.K. Venugopal. They speak volumes on they add luster to the book. No less a person than Dr. Upendra Bakshi has opined that the book is a landmark contribution to the evolving landscape of Indian family law in a globalized world. This encomium contains everything about the work as well as the authors. Without any tinge of exaggeration, I can say that this book will be treasured by the judges and the legal practitioners alike as a Bible on the subject. My hearty congratulations to Mr. Anil Malhotra and his illustrious son, Mr. Ankit Malhotra, for the excellent work assiduously undertaken by them. Thank you.
Thank you. Thank you very much, sir. Over to you, Ramakrishnan, sir.
Good evening to everyone. I really to confess that I have not gone through the book. But anyhow, when it is written by Anil Malhotra, we can think that what it will contain because of the vast experience he had on the international arena on family issues. rightly pointed out by the speakers, our family law itself is evolved not on the basis of the statute, but by judgment laws. And there is no law now available, especially when the trend of cross-border issues are coming up. See, when you are not able to say something about, because I even referred a matter to Anil Malhotra when a person from foreign has called me to say that they married in London. Both are Hindus, both are Indians, because still they hold the Indian citizenship, but it was not registered here. So the question will be whether applying for the visa here, unless you declare that you are the wife, you may not be able to get it. So when I asked him, he said that why should they go for those things? They'll let them come as an ordinary citizen of London and say India and come there and let them come and conduct a marriage and then resolve it. See, that is a way in which things are going on, especially when there is no law dealing with that. And as rightly pointed out, ultimately the sufferer is a child. The concept of unification of family has given a go by nowadays, because almost all the family courts have become a diverse courts than reconciliation courts. It is not that there is no provision in the Family Court Act that you will have to undergo a mediation, because even before going to the mediation, you got a counseling panel is there. You will have to go to appear before the counselor. Counselor will have to interact with. They will have to send them their report. Thereafter, even after coming there, you will have to again go for mediation. Mediation process is also going on. Then there is also a provision where the judge himself or herself can mediate before passing a judgment. All these things are there in the family court, but how far it is successful is a question, because the mindset of the people have not gone to the extent of accepting these aspects for the purpose of resolving issues in a better manner, which is beneficial to both, not only both, but also the child also. So once that aspect has been taken into consideration, then probably most of the issues can be resolved, because it is being, as rightly pointed out by some of the speakers, that it has been taken as a weapon. Because going to the court, contesting it, and ultimately when it goes to the Supreme Court, they become, by the time passes, the wisdom dawns on them. That is the reason why almost all cases of family court issues are settled in the mediation in the Supreme Court. Because by the time they lost everything, they are not able to withstand the litigation expenses, time consumed for the purpose of resolving the issues, etc. There must be a compulsory mediation before going to the litigation. That is there, but even in the recent Mediation Act, there is a provision that you'll have to go for mediation first, then only go to the court. But how far that is being adopted by the lawyers as such? That is the main issue, because unless they go to the court, you file an application, there is no meaning in going to the litigation. One. Second, the people are coming to the court on the spur of the moment issues that is happening in the family. Subsequently, it is being triggered by the persons who are around them, and they are not able to resolve it in an amicable manner because of the influence that has been exerted on those people. Both, I don't say the only female or male, that's not happening. And parents are also to some extent is responsible for that. And as rightly pointed out, Malhotra, I love my father and mother. Where is the grandparents now? They are out of the family now. See, that is the main issue, according to me, is all for this deterioration in the family issues. Because there must be somebody to look into the issues and resolve it in the family manner, in an amicable manner, when you are sitting together in the family. But when you goes out of it, even the Supreme Court also saying, once you are given in marriage, forget about your son or daughter. They will decide those issues. Why should you unnecessarily poke your nose there? And we are telling that daughter-in-law or son-in-law, because though you are not a son in the what you call biologically, but by virtue of the law, you have been conferred the status of a son and a daughter in the family in which you are going. Are you not expected to maintain that status and that responsibility? Once that is done, I think that to some extent, all these problems can be solved. But I do not know in the recent scenario whether that will be possible or not. Because even the courts are not able to equip with that principle in mind. And they will thinking that just already the what you call the family has been divided, the unity has come, you have differently going on. Why should unnecessarily interference causes some trouble in the family? Why can't you keep away from the family issues so that they let them be happy? So parents are also to some extent equipped with that tolerance, I can say, and they are somehow adjusting with the things that is not going on now. That is the uniform synonymous things that is going on. So change must come in the society first. Under the change come in the society, I don't think there will be any possibility of the protecting the importance of the family in the society, because earlier the principle was family is a unit of the society. Now can we say that it is a unit? I do not know. That's the way things are going on. Anyhow, the things that has been coming in the discussion are all things to be done in the right perspective by the courts and also by the lawyers. Because lawyers must think that it is not a earning process when you are dealing with the family court issues. It is a life-saving or society-saving service that you are going to do for the purpose of protecting the unity of the family, for the purpose of protecting the society itself. If that concept must come to them, probably the principle of mediation will go. And as rightly pointed out, the child is a voiceless person in the case of custody. Even if you call the child, as Mustaque has said in some other cases, we are only getting a shorter time to interact with the child. And the nowadays children are intelligent. They know what is right and what is wrong. See, the question is how far we will be able to rely on the statements given by the child at the time. Because whether, as rightly pointed out, you are tutored or you are under the influence of the person with whom they are living, all those things matters a lot. And the Family Court Act says that the Evidence Act is not applicable. I do not know why we will have to revamp the Evidence Act, etc. Because when the law says that it is not applicable, and why the people are not adopting that principle for the purpose of taking other issues also for the purpose of deciding the issue, I do not know. So these are all the areas where a lot of training is also required. And as regards the cross-border issues, really the training is not available for the trial court judges. They must also get an open arena for this purpose for discussion and also to involve that. Probably Anil Malhotra's and his son's book may be helpful for them to evolve a principle by which they can tackle the issues in an effective manner, which is beneficial to the family as such. Thank you very much for giving an opportunity. And I congratulate the Anil Malhotra and son for the great book. Thank you.
Thank you, Ramaseshan sir. Like you said, father-in-law, mother-in-law, son-in-law, in-laws are there. If not treated properly, they will become outlaws. So
and grandparents are marginalized.
the in-house mechanism available for mediation, conciliation, etc., is now absent. That's the main reason, maybe. Now let us hear from the publisher himself. Mr. Srish Chandra is here. Over to you, sir.
Hi, good evening, everyone. My name is Shri Chandra, and I represent Oak Publishing. I'm privileged to be a part of this gathering of this book release function, and as Mr. Malhotra has already said, that this is his second book with us. The first one being the Global Indians in the Law. We are really proud to have partnered with Mr. Anil Malhotra and his worthy son, Mr. Ankit Malhotra, in publishing this authoritative guide on international family law, which not only has been liked and appreciated by practitioners in India, but overseas as well. As Oakbridge, we have been fortunate enough to work with him for the second time. It's a great learning experience when we work together. His passion for the subject not only keeps us on toes, but also, encourages us to do our best. So we have done our bit. I hope you people, I mean, all the practitioners would like this book as much as we loved developing it with the authors. And I sincerely hope that people find value in this work. And I wish both the authors all the best and great success to the book. I mean, it's as a it's in my own expectation. So needless to say that, but I wish both Anil Malhotra sir and Ankit for this great contribution to the jurisprudence of family law. Thank you so much.
Thank you, Suresh. Yeah.
Just to point out, Ranjit is present. This was the first book with Oakbridge, which Srish mentioned, and it was authored by myself and Ranjit Malhotra. And that is where our journey started with them, and it will go on now. Let's hope for the best.
Thank you.
We expect the next one real soon, sir.
I want to just add to what Justice Ramakrishna said about the interpretation of the word family and what Justice Roshan Dalvi meant. What Justice Roshan Dalvi meant was we have to read down as we do in law. Father means grandfather, in brackets paternal and maternal, and mother means grandmother, paternal and maternal. That is how the family structure in India is built. We have an inbuilt counseling, arbitration, mediation mechanism. Abroad, social services do it. We have this mechanism inside. And this is the protective mechanism which Justice Ramakrishnan is talking about, which we need to recreate. Because within the family, the mediation, the arbitration, the settlement can be better sorted out than by courts and lawyers. So, with supporting the principle of reading down, we have to read Justice Roshan Dalvi's interpretation of the word family in the Indian context to have an inclusive meaning of the parents on both sides. They are not there, but then we won't be able to make up the definition. Otherwise, family will become too long. So, Shyam, back to you. Take it to the floor.
Yes, and as we come to the close of today's deliberations as well as the book release ceremony, should we open up for discussion or could we just, I mean, it's already 7:10. Anything to be added from your side, sir, as the author's remarks? It'd be most beautiful.
If we have anybody waiting to say something, we can take him on. Otherwise, Ranjit can do the wrap up.
What I would like to just recap is that at least 7 issues that came up today. Number one being, why not have counseling even prior to mediation? Because mediation and arbitration, etc., contemplates or presupposes an issue having been, I mean, a dispute having been created. Even prior to that, if when there is symptoms, it could be treated. That is one way. And number two is pre-litigation mediation. Should it not be? Why can't we make it mandatory and requisite changes, etc., could be made in the Arbitration and Conciliation Act? And thirdly is why not, with cautions and otherwise irretrievable breakdown of marriage, be made a ground of divorce statutorily, so that unnecessary trading of charges and accusations could be avoided. Then fourthly, all this will not, I mean, are we not trying? I mean, of course, we'll try to keep the social fabric intact by having these units intact. But when it comes to parting, why not it be graceful parting? The terminology used was really wonderful. And next is, should there not be a relook on the Guardians and Wards Act? And the best part was what Justice Mustaque said, independent assessment of welfare of the child, let it be CIM or CIL, both if implemented, it will give and assist the court to at least take a decision in the best interest of the child instead of getting carried away. I mean, it usually said who gave the last chocolate decides the decision-making power of the child. So that also. And Ramshan sir rightly said the in-house mechanism has to be strengthened because it's the grandparents and that protective umbrella or a place where you can confide or you can say, and maybe we may not take it in the face value, but that would give us a buffer zone so that matters won't get escalated. Alex, you would like to say something on that?
Shyam, there I would recommend, there's a movie called Kramer versus Kramer featuring Dustin Hoffman and Meryl Streep about 45 years ago. Kramer versus Kramer, which everyone would enjoy. I strongly recommend that. It's an old movie, Kramer, Kramer versus Kramer. It's a child custody movie.
Fine.
Strongly recommended.
So, Shyam, you have to arrange a screening now.
No, I will do that. And when the person says it from the other side of the universe, 7 seas apart, and in the earlier morning hours from Pennsylvania, when Alex says so, it's good. And I'm sure that that movie is available in the net, I believe. It is.
Yeah,
it is.
absolutely. Meryl Streep and Dustin Hoffman.
Really nice. Thank you very much. And let us now come and request Ranjit ji. It's all over to you. You'll have to unmute. The only platform wherein nobody will be muted. So please go ahead. You'll have to unmute.
No, we can't hear you, Ranjit.
He has not unmuted.
I'll just give you a, yeah. Now you'll see a pop-up.
Yeah,
Yes.
got it. Can you?
Loud. Okay, carry on.
Loud
Yeah.
and clear.
Okay. Shyam, as first of all, thank you so much for being the perfect anchor this evening. Right before Anil was putting the onus of the screening, there is the onus on him of hosting a dinner evening. This is the only downside of having an online interview, online discussion. There is no nice dinner evening which follows. We are very, very grateful to Justice Mustaque for being the chief guest this evening. In fact, Anil always looks forward to him as the pole star in God's own country. See, Chandigarh and Kerala is like being East Coast and West Coast in the US. I think Justice Mustaque is not there, but nonetheless, he's here very much. And
yes, he is here.
Yeah, that's very nice. In fact, the day is not far that all the suggestions which have been thrown in this evening, which will be put to implement, which will be put forward to implementation by him under 142. First was his own suggestion of international mediation. Then Justice Garewal mentioned about compulsory probate of the wills. I mean, land is a big issue in the north. And then Deshmukh madam mentioned about pre-litigation mediation. And Dalvi ma'am mentioned about child independent mediators. So 4 suggestions waiting under 142. I'm sure it has been stored in his database. Anil often recalls with pride, joy, and reverence all the contribution that is made by Justice Mustaque in this area of law. Generally, what happens is family law is considered to be a poor country cousin or a stepchild. And international family law, there are inputs sort of lacking, as we have discussed this evening. And Justice Garewal, who again has made very valuable contribution. He is, as always, very, very modest. He's not sitting in rural Punjab. He sits in a very tastefully 5-acre estate, very generous host, especially if you are with him at this time of the evening. And of course, we owe huge debt of gratitude to Mrs. Geeta ma'am and Deshmukh ma'am. for their very eloquent contributions. Deshmukh ma'am, as we all know, is the first and last word for all big and small family law litigation in Mumbai. You know, beneath her gentle exterior, she always very seamlessly navigates complex family law litigation, and her emphasis, ethos, edifice is always to downplay with a view to coming to a successful resolution. Geeta ma'am very rightly pointed out that the good times have vanished. That is why the king of good times is hiding in in countryside in England while giving online interviews, knowing that he will never be able to come back to India. And then she had a very good point that, you know, that the process of visitation is like the husband and wife going to a boxing ring. The child becomes a trophy. And as Deshmukh ma'am said, the voice of the child is lost. And again, then Roshan Dalvi ma'am pointed out that we need greater clarity. Justice Ramkumar very eloquently summed up the entire landscape. He gave his rich perspectives. Then Justice Ramakrishnan Iyer gave a very nice summary rundown of the contemporary interaction of law and society. And that is how law evolves. You see, what happens is, like anywhere else, even in the European Union previously, commercial laws are given a lot of priority. And, you know, family law is one area that continues to be neglected. And of course, I will be failing in my duty if I do not acknowledge all the hard work of the anchor for setting up this wonderful evening, and the publisher. And I'm sure I know my brother very well, much more than you would know. He would have put you to a lot of scrutiny in terms of editing, etc., sending you mail and mail after mail messages. Anyway, you were cautioned by Justice Sikri about that, and it's good. It's worked out well in a very positive perspective. So thank you once again to everybody, and of course, we expect profound gratitude to Justice Mustaque for taking out time from his extremely busy schedules. One could see that he's had a busy day in court, and he jumped straight on the platform to lend his rich perspectives. Thank you, everybody. Good night, and the authors owe everybody a nice dinner evening, which is normally a launch in case of a proper physical launch, right?
So, I mean, next flight to Punjab or Chandigarh, we are on it.
With tickets to be given by the authors.
That is good.
Yes.
Whether you're domestic or international.
Thank you. Thank you very much.
Thank you. Good night. Stay safe.
One moment. Shyam, very quickly, I owe a debt of gratitude to Shyam for conducting this wonderful 290th edition of Littles. I call him the Amitabh Bachchan of the legal industry. And if
Amitabh Bachchan might commit suicide.
Sir, you are a king in the legal world.
Let's see.
You are no competition for him, but you do a tremendous job. And I strongly urge the Kerala Judicial Academy to partner events with him so that knowledge sharing by Shyam's platform of resource persons other than judges is put to good use, and valuable views of esteemed speakers all over India, whom he has very, very slowly taken into the umbrella of Littles, are utilized by the Kerala Judicial Academy so that Kerala can shine more and the waters will be more clearer and less murkier than what they were before. So, with gratitude to Amitabh Bachchan of legal industry.
We cannot say Justice Mustaque. We cannot see his picture on the screen.
Mustaque is...
Yeah, he is here very much. That is third from bottom.
So not to be on my screen. Right.
So on that note, I owe a special debt of gratitude to Justice Dalvi, whom we ought to have had as a speaker. So through Shyam, I'll request ma'am to please kindly share her address so that we can send a signed copy of the book to her. And thank you, Shyam, for this wonderful coordination and the sparkling face and lovely glow which you have as a senior advocate. And I hope the bench doesn't steal you and you keep doing the
If it stays much further, I think I'll hit the ceiling or something like that. For the time being, it's good night and goodbye. Thank you.
Good night. Thank you.
Night.
Please, the
Thank
bat.
you. Good night.